kick off this particular issue in a practical manner and to set you in a scenario. Unfortunately, it should have there would have been on this slide a little case study, but some technical things went wrong. So I'm just gonna give you a set of facts. And just before I do that, a bit of background. The ICRC has actually led an expert process on the interplay with regards to the use of force against persons as regards the paradigms of conduct of hostilities governed by IHL and law enforcement. So mainly deriving from human rights. And because we realized, especially in situations of non-international armed conflicts, you might face certain situations where it is not so easy really to decide which of these paradigms should apply to a set of facts. And this can be because this set, there are mixed situations. That's one example, and one case, a short case I wanted to give you is, imagine you're in the context of a non-international armed conflict, and you have a demonstration that occurs against the government's, say, repression of the insurgency. And in the course of that demonstration, hundreds of people gather in the main street of the capital, where also governmental armed forces are engaged, and are engaged also generally in hostilities against fighters. And in the course of trying to manage this demonstration, the demonstration turns violent. So the demonstrators start throwing rocks, but there are fighters actually that take advantage of the situation and mix in between the violent demonstrators. So my question to you is, in this kind of set of facts, what paradigm under the use of force would you apply? Would it be conduct of hostilities? Would it be law enforcement? Would it be both?
The IHL one, because there are combatants and they're using force. If we reach a certain threshold, let's say, and IHL rules would allow to distinguish between the demonstrators who are civilians or non-combatants, and then the combatants. So that would give us what we need for proportionality and assessment of the action and their legality.
Although remember from the previous session, then we're talking about IHL proportionality, where we're only concerned with collateral damage and some collateral damage, and it means that some harm to civilians who are not involved is legitimate,
yes, exactly.
As opposed to human rights proportionality, which would take into account even the effect on the fighters.
Exactly.
So we need to remember when we're saying, if you're saying the IHL one, then we're using IHL proportionality, which clearly allows for collateral damage amongst the uninvolved.
And it would still absolutely.
Yeah, but less at a low.
Absolutely, and it would still not make the civilians a legitimate target in any way.
Perhaps using human rights law there instead of IHL, because you said under these limited facts that you've given us that we're trying to make recommendations on ROE. Most typical ROE will require, before taking force against a combatant, to positively identify them as a combatant. In the facts that you've described, it's a commingled crowd, and therefore the presumption must be that they are all civilians unless you can do the positive identification to use military force. So I would begin with the assessment, these are all civilians that may require a later status determination to apply different rules, but as far as the initial use of force in a commingled crowd, under the circumstances you described, I think I would be recommending human rights.
the way I understood there was NIAC. I would agree and maybe build upon Etienne that it's law enforcement paradigm for me, but at the same time, if we're talking about continuous combat function, is the question how you're going to approach from the state perspective if you are suggesting to the state officials how they have to behave. I would agree human rights law, because continued combat function will be very dangerous in that context, but then there is another question which comes to what you have mentioned. Now, in that context, the armed forces will be allowed to use, for example, the weapons which under IHL is prohibited. And the state will think, wait a minute, then I'm going to have a problem from the IHL. But in overall, if I was arguing and suggesting for the state how to behave in the demonstration, I would say law enforcement paradigm because of proportionality criteria in IHL with the civilians present on the ground.
That's a really interesting point. I'm assuming Alexander will pick up on the weapons, because it may be that law enforcement actually allows better weapons than IHL in this. So, Alex, you want to?
No, very, very interesting. I could see that a majority of the room were leaning towards applying a law enforcement model. So, of course, then the first question that has to be asked, yes, but there are obviously fighters within the crowd. Does the law enforcement model really allow us to respond effectively even to the fighters within the crowd? And the answer would be yes. So if they, of course, represent an immediate threat to life, yes, the use of force can be directed against them. Just to also pick up on, perhaps taking it backwards, from that last point, because it was a particularly interesting point in terms of the weapons. Here you see an example actually where IHL is even more protective in that sense than human rights law. Because obviously if you apply a law enforcement model to the entire situation, you would allow, though if it's armed forces that actually conduct the operation, you would allow them to use riot control agents, or also hollow bullets, for example. Things that would be prohibited under IHL. So use of riot control agents under IHL as a method of warfare, as you know, is what is quite consensually regarded as prohibited, because it would lead, of course, the potential of an escalation in response with even more powerful chemical weapons. So for that reason, there is this specific prohibition. So in terms of applying the conduct of hostilities model, here, of course, yes, the fighters are lawful targets, but then you might face an issue here, especially if the crowd is numerous around them, in terms of proportionality and precautions. So effectively, if you don't have very precise sniper capabilities, the upshot would be that actually you'd have to refrain even from targeting the fighters in that situation. There was another very interesting point made in terms of leaning towards the human rights paradigm, because most rules of engagement would already require to positively identify if someone is a lawful target or not. In fact, one interesting result of this expert process was to recognize that in these difficult situations, especially under the IHL precautionary, even under the IHL precautionary obligation to positively verify that the person in front of you is a lawful target, that this would imply a kind of escalation of force procedure that would be very common under human rights law. And just also a remark on the rules of engagement. No matter what for legal reasons, what kind of mindset you would go into the operations, rules of engagement are usually not only informed by law, but also for policy reasons. And in many respects, these would be quite stringent. So in essence, then even if legally you would adhere to a more permissible standard for policy reasons, you might resort even to stricter standards as laid down in the rules of engagement. What surprised me though was that no one actually suggested to apply those two in parallel, meaning against the fighters, conduct of hostilities, versus against the demonstrators, the rest of the crowd, human rights. In fact, this was the result of the debates in this context, because it was simply said that legally, of course, it is the solution that would make most sense, to recognize that there are actually two different situations, although these two different situations happen to be very close to each other. However, still, of course, as a practical matter, very difficult to implement. That's why, you know, at least in the ICRC conclusions, you might have a fundamental difficulty, of course, if you go for IHL against the fighters, precisely to distinguish who is who. Is it a fighter having a continuous combat function? Is it a civilian directly participating in hostilities? Is it merely a civilian throwing rocks participating in a demonstration, but that otherwise, but for that spontaneous manifestation of their anger, does have nothing to do with the collective resort to hostilities that would give you the kind of belligerent nexus to regard that person as directly participating in hostilities. So that's very difficult, and in cases where it is difficult, there is the possibility to effectively to fall back on the law enforcement paradigm. So I think I'll stop it there.
I just want to clarify quickly something on proportionality that was said, just so don't leave you with a misconception, and then I'll turn to Marco. The proportionality, and I was saying earlier that proportionality is different between the two. Under human rights law as well, proportionality, you could still end up with harm to others and still say that it's proportionate. The reason that the human rights law proportionality test is more stringent is because it requires you to take into account the harm to the person that you're targeting. Whereas the IHL proportionality, as we'd said earlier, the person that you're targeting, if they don't have civilian protection, you don't even need to count them into proportionality. You only need to count the harm to the others. And in the human rights law, you'd need to count the harm to the person you're targeting and the harm to the others. And then still, depending, you could reach all sorts of solutions. But that's also linked to the question of weapons. And I think it's interesting whether indeed to say that certain weapons are banned is more protective. Is that necessarily the case? Because, for example, looking specifically at this issue of proportionality, if under IHL you're not allowed to use hollow point bullets, dum-dum bullets, right, and the only weapons that you have are regular bullets, then you will more likely be harming not just the person you're targeting, but the bullet will go through them and possibly kill or injure another 3-4 people. If you're using dum-dum bullets, you can target the one person, it hits them, and that's what dum-dum bullets, hollow point bullets do. They go in and they don't come out the other side. It causes horrible damage inside, but it's safer for the other people around. So in theory, you could argue that allowing certain weapons is more protective, and it's interesting because you have this in human rights law, and there have been some cases, such as the Gulic case in the European Court of Human Rights, where one of the things they're saying to the state, you go out to deal with demonstrations like this, you need to have the right kind of equipment, the right kind of riot control to minimize harm. And if you go out without it, then you're violating human rights. So you could even argue under human rights law, you're required to use certain methods that you might not want to be using under IHL, which is complicated. I'll turn over to Marco if you want to comment on this, and then straight away move into detention.
Just one sentence. When I am asked what is the greatest difference between human rights law and IHL, It's the distinction between civilians and combatants doesn't exist in human rights law. And that's, in my view, for the use of force, the big issue. That everyone is simply a human being, and therefore you have to individualize the use of force, while in IHL, according to its letter in international armed conflict, and now increasingly for all kind of constructions in non-international armed conflicts, you create categories of people, which in the reality of fighting in a battle is probably inevitable, because you cannot individualize as much as the police can in a law enforcement situation.